Thank you, Mr. Speaker. I do have additional questions for the proponent of the bill.
Representative Blumenthal in this case?
Yes, Mr. Speaker.
Ready yourself, sir. He looks ready.
Thank you, Mr. Speaker. Where we left off, we were talking about, we used the example of Texas, where if somebody, a party in Texas sues an abortion provider in Connecticut for something that was done in Connecticut within the four corners of the law in Connecticut, they then get a judgment in Texas against that person. That person can then bring suit in Connecticut and get a judgment against that party from Texas or the other respective state. So I guess my question, my additional question for Section 1, as it relates to Section 1, is if Connecticut residents or groups of Connecticut residents or other groups in Connecticut go to another state and somehow assist in the initial lawsuit, can the abortion provider in Connecticut also sue those individuals from Connecticut or those groups from Connecticut that went and assisted out of state in that initial lawsuit? Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, with the good representative mind restating his question, I was a little confused by it.
Representative Lanoue.
Certainly. The initial lawsuit, we'll use the example of Texas. A party in Texas sues a provider in Connecticut. During that initial lawsuit, if there were individuals from Connecticut or groups from Connecticut that went out of state to assist that party during the lawsuit, whether it's research, helping in some way, assisting in that initial lawsuit, would there be standing in the state of Connecticut for the abortion provider to seek a judgment as outlined in lines 10 through 24 to go after those individuals or groups from Connecticut? Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, I think I understand the good questioner's question better now. So this provision in Section 1 only applies to situations where the person who's bringing the action in the original lawsuit, they were sued for something that they did that had some relation to Connecticut. Some part of the act that they were originally sued for took place in Connecticut. So if someone goes to another state and does get sued for something there and it has no relation to Connecticut, then they would not be able to bring an action under Section 1.
Representative Lanoue.
Thank you, Mr. Speaker. Again, just to make sure I'm clear, during that initial lawsuit that's filed out of state that related to something that happened in Connecticut, if there are people from Connecticut that went down to another state or to assist in that initial lawsuit, they would not be held liable for legal damages as what's outlined in specifically lines, looks like 17 through 24. Am I correct? Through you, Mr. Speaker.
Representative Blumenthal.
I think the good representative is correct. The only person who could be sued under those circumstances would be the person who originally brought the lawsuit against the person who was doing the acts here in Connecticut.
Representative Lanoue.
Thank you, Mr. Speaker. I thank the good representative for those answers. Now, if I'm also reading this correctly, specifically in line number 17, it says the 1617 damages from any party that brought action leading to that judgment or has sought to enforce that judgment. So if there was if somebody was trying to enforce that judgment here in Connecticut, let's say they went to an attorney that's practicing law here in Connecticut, they have a judgment from another state against a abortion provider, and they ask that attorney to try to collect and place a lien on assets, for example. They go to a state marshal to help enforce that judgment. Would those folks be liable if in a countersuit by an abortion provider. Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker. As I read the language, it would only apply to the party who seeks to enforce the judgment. So it would be a party who sought to enforce the judgment, a litigant, rather than an attorney for that litigant.
Representative Blumenthal. Representative Lanoue.
Thank you, Mr. Speaker. Now, lines 119 through 125, would the good representative kindly just summarize what's in those lines to make sure I'm clear? Through you, Mr. Speaker.
Representative Blumenthal, would you mind summarizing those 6 lines, sir?
Through you, Mr. Speaker. This basically says that if a prosecutor or a state agency in another state is holding a grand jury investigation or some other investigation related to a criminal proceeding where they're seeking to enforce a summons here in the state of Connecticut to someone to appear, or they command information to be given essentially under a criminal subpoena, that summons or subpoena will be enforced unless it is seeking information about reproductive health care services that are legal here in the state of Connecticut. And this provision does not apply if the conduct that underlies the original criminal investigation or action in the other state would otherwise be illegal in Connecticut. Through you.
Representative Lanoue. Thank you, sir, for your summarization.
Thank you, Mr. Speaker. I thank the good representative for that answer. If I'm understanding this correctly, so if there was somebody who, from Connecticut, a nurse or an abortion provider, was in another state and was involved in an abortion procedure there, as long as they were following Connecticut law, and there was then opened a criminal investigation or a subpoena for somebody to appear as a witness in a criminal investigation or grand jury investigation, no Connecticut judge would issue such summons for them to go back to the other state. Am I understanding that correctly? Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, that is correct, as long as the individual was following Connecticut law and they did not otherwise violate Connecticut law through their acts. They would not be summoned for that proceeding to seek criminal penalties against someone for reproductive health care services that are legal here in the state of Connecticut.
Representative Lanoue.
Thank you for that answer. Under current Connecticut law, parental notification or consent for a minor to obtain an abortion is not required under current Connecticut law. Is that correct? Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, that is correct. However, I will say, and if Representative Gilchrist has additional material to prepare on this, we do have an extremely strong counseling statute for minors, which specifically specifies that the counselor must introduce the topic of parental notification with the minor and discuss it with them. And if the minor decides that it is in their best interest after that counseling not to talk to a parent or guardian, then that must be specified in the signed certified form that is executed as a result of the counseling. Through you, Mr. Speaker.
Representative Lanoue.
Okay, thank you for that answer. And again, be clear, make sure I'm crystal clear. Again, even if there's a counseling session commencing, there is still no parental notification or consent required within the state of Connecticut. Through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, the answer is no.
Representative Lanoue.
Okay, thank you, Mr. Speaker. Now, there's other states, namely the state of Rhode Island, which my district actually borders, where parental consent is required. There are 37 states across our nation.
Representative, let's not allude to other states. Let's stick to the 4 corners of the bill, please. Okay? Thank you, sir.
Thank you, Mr. Speaker. Again, I just want to make sure I'm interpreting in these lines correctly and applying that this. I want to give an example of where this law can go if the underlying legislation passes. So if I may have a little latitude here.
I'll do my best, but we just don't talk about other legislatures or what they pass or what their laws are. We talk about Connecticut laws, sir.
Okay, but in fact, talking about an offense in another state is actually applying this legislation here. That would actually fit into what we're talking about here, correct?
Ask the question. We'll see what it says.
Thank you, Mr. Speaker. So, for example, the state of Rhode Island, there's a parental consent requirement
Nope.
in another state.
Representative, let's stick to Connecticut law. Thank you.
If there was a summons issued here in Connecticut by another state requesting a nurse or somebody who participated in another state where there is a parental consent requirement and there is an open criminal investigation that no parental consent happened, they need that witness testimony before a grand jury. Under this legislation here, in lines 119 through 125, that would be denied. Am I interpreting that correctly through you, Mr. Speaker?
Representative Blumenthal.
Through you, Mr. Speaker, as long as the individual did not do anything that violated any law under the state of Connecticut, the summons would not be issued.
Representative Lanoue.
Thank you, Mr. Speaker. So again, just make sure I'm crystal clear and I know what I'm looking at here, and I clearly know what I'm voting on behalf of my constituents. If as long as the doctor, the abortionist, a nurse who may be assisting in an abortion across state lines is following Connecticut state law where there's no parental notification or consent requirement, they would not be bound to have to go and testify in that other state. That is correct, through you, Mr. Speaker.
Representative Blumenthal.
Through you, Mr. Speaker, they may still be bound to come and testify in that other state under that state's powers or the power of third states, but the summons would not be executed through the courts of Connecticut. And I would just point out that in the examples you're listing, in many of these examples, they would be probably quite rare because the individual you're talking about would probably just stay here, and the person who is seeking the abortion care would probably be the one doing traveling. But Connecticut would not execute that summons in that case. Through you.
Representative Lanoue.
I thank the representative for his answers. I do have some questions regarding section number 7 of the bill, if I may.
Is that the public health section, sir? It looks like it is. So Representative Gilchrist is prepared, and you may ask her question, sir. You may proceed.
Thank you, Mr. Speaker. A question to the good representative regarding section 7. Can you please explain what the purpose of this section is for? Through you, Mr. Speaker.
Representative, could you provide a summary of the section, please?
Sure. Through you, Mr. Speaker, current state law, which was passed in the 1990s, only allows for physicians to perform aspiration abortion. It also, at the time in the 90s, didn't even consider medication abortion. So what Section 7 does is codifies an Attorney General 2001 opinion that APRNs, PAs, and nurse midwives can perform medication abortion, and it removes the physician-only barrier by allowing APRNs, PAs, and nurse midwives to perform aspiration abortion. Through you, Mr. Speaker.
Thank you, Madam. Representative Lanoue.
Okay. I thank the good representative. Again, so to make sure I'm clear, APRNs, midwives, and physician's assistants will be allowed to perform abortions, assuming this underlying legislation passes. Is that correct, through you, Mr. Speaker?
Representative Gilchrist.
They will be able to perform aspiration abortions. Through you, Mr. Speaker.
Representative Lanoue.
Okay. Under line 188, It talks about medication abortion and aspiration abortion. Could you please briefly describe what a medication abortion is compared to an aspiration abortion? Through you, Mr. Speaker.
Representative Gilchrist.
Yes. A medication abortion is typically used until the 10th week of pregnancy. It's performed through taking two medications in pill form, Milprex and Cytotec. These drugs work together to end the pregnancy. Whereas an aspiration abortion can be performed up to 12 weeks of pregnancy. A doctor begins the vacuum aspiration procedure by inserting a speculum into the woman's vagina. They then apply medication or use an injection to numb the area. Through you, Mr. Speaker.
Thank you, Madam. Representative Lanoue.
I thank the representative for her answer. What will the training consist of for these new group of providers that will be allowed to perform abortion? Through you, Mr. Speaker.
Representative Gilchrist.
There are, the American College of Obstetricians and Gynecologists has outlined quite an extensive training. And so, as I mentioned earlier to the good representative, the ranking member, this in no way changes the scope of practice for these provider types, and so they would still be working in collaboration with or under the supervision of a physician, and so they would coordinate with them with regards to the training. Through you, Mr. Speaker.
Thank you, Representative Gilchrist. Representative Lanoue.
Thank you, Mr. Speaker. Now, what happens if someone in one of these respective categories, the APRN, a midwife, or physician assistant, who currently practices in these areas, do not want to perform either one of these abortions or one of these abortions? Do they have a right to refuse to do so? Through you, Mr. Speaker.
Representative Gilchrist.
In no way does this bill require any of these provider types to provide an aspiration abortion. Through you, Mr. Speaker.
Representative Lanoue.
So in no way will their license be in jeopardy if they refuse to perform these abortions. Through you, Mr. Speaker.
I believe she answered it, but we'll have her do it again. Representative Gilchrist.
Correct. Their license would not be in jeopardy. Through you, Mr. Speaker.
Representative Lanoue.
Thank you, Mr. Speaker. Now, how about going forward? The APRNs, midwives, or physicians assistants that are in training, that are going to be going to school, that want to get certifications, will part of their training require them to be trained in performing abortion? Through you, Mr. Speaker.
Representative Gilchrist.
The bill before us does not speak to any additional training for these provider types outside of the aspiration abortion. Through you, Mr. Speaker.
Representative Lanoue.
Okay, thank you. Again, people, if there's a young person that wants to go to school to become an APRN or a midwife or a physician's assistant, will for these new students that are going to be in training to be one of these providers, will it be required that they participate in some way in abortion or be trained in abortion in order to get their certificate? Through you, Mr. Speaker.
Representative Gilchrist.
In no way does Section 7 change the requirements of schooling with regards to these three provider types. Through you, Mr. Speaker.
Representative Lanoue.
Would this legislation somehow prompt or somehow force schools to incorporate abortion certification, abortion training to these new cohorts of students? Through you, Mr. Speaker.
Representative Gilchrist.
I don't believe so. Through you, Mr. Speaker.
Representative Lanoue.
Would there be, in the event that would happen, is there an ability for one of those students in training to be one of these providers? Would they be able to take a moral, religious, or conscientious objection to the abortion certification? Through you, Mr. Speaker.
Representative Gilchrist.
I would not be able to speak to that because it's not covered in this bill. Through you, Mr. Speaker.
Fair enough. Representative Lanoue.
Thank you, Mr. Speaker. Line 181 of this bill talks about how these providers will be able to perform abortion prior to the viability of the baby, essentially. How are we defining viability through you, Mr. Speaker?
Representative Gilchrist.
We currently don't define viability. I could certainly give you a definition if you'd like, through you, Mr. Speaker.
Representative Lanoue.
Well, yeah, I mean, I'm curious. I mean, what point is the baby determined to be viable under current law? Through you, Mr. Speaker, or under this proposed legislation? Through you, Mr. Speaker.
Representative Gilchrist, the question pertains to the pending legislation. So, to that extent, that would be the question, I
Yeah,
think.
viability is not defined in this legislation. Through
Thank you,
Mr.
Madam.
Speaker.
Representative Lanoue.
Okay. Again, I'm trying to understand at what point would this be any abortion, or I'm just trying to. It's saying that when up to the point of viability. So, I'm just trying to understand what would be voting on, how much latitude would be given these providers to perform an abortion on a baby that is not viable. I'm just trying to understand up to what point is that the case. Through you, Mr. Speaker.
Representative Gilchrist, we're asking in a lot of ways here, so let's see if we can add some clarity, if we can.
Sure. So, Section 7, the bill before us, speaks to two types of abortion: medication abortion and aspiration abortion, which are both performed within the first trimester of a pregnancy. The lines you're reading are current state statute, which does say that no abortion may be performed upon a patient after viability of the fetus, except when necessary to preserve the life or health of the patient. That is not changing in this section from current state law. Through you, Mr. Speaker.
Thank you very much, Representative. I think that gets to the heart of the question. Representative Lanoue.
Okay. Oh, thank you, Mr. Speaker. Again, would viability be measured by how developed the baby is in the womb, as far as hands, feet, ears, arms, legs, neck, or head, a heartbeat, nervous system being in place? Is any of that criteria taken into effect when it comes to viability? Through you, Mr. Speaker.
I believe she's answered the question, which is that these are both performed within 3 months.
Okay. Now, on line 182, it talks about a carve-out for an exception for viability if it relates to the health of the patient. Just to make sure I understand current law, what's defined as health? Through you, Mr. Speaker.
Representative Gilchrist.
This would relate to if an individual is having complications in the pregnancy that would negatively impact their health and well-being. Through you, Mr. Speaker.
Representative Lanoue.
Okay. Again, how broad of a term is that? I mean, well-being. Are we talking about a headache? Are we talking about financial stress? Are we talking about anxiety? Some other type of health issue? I'm trying to understand how broad we're going with this. Through you, Mr. Speaker.
Avoiding the hypothetical question, I'll ask it another way for you. Is there a definition, Madam, in state statute of health?
I don't believe so. Through you, Mr. Speaker.
Representative Lanoue.
Okay, I thank the representatives for their answers. Mr. Speaker, what we have before us is essentially two pieces of legislation that got combined. I will be voting no today for a couple of reasons that are particularly troubling to me. The first was during the question and answers when we talked about if there is a abortion provider or somebody who is assisting in an abortion in some way that took place across state lines, and in these other 37 states where they require a parental notification or parental consent requirement. If I choose to live there as a parent, and I have a young daughter, and I choose to make my home in that state, and part of my reason for doing that is because they have strong parental notification or parental consent laws, and somebody trespasses into on my parental rights in that state and performs an abortion on my minor daughter without my consent or without my notification in some way, and a criminal investigation commences, essentially, because that's not the law in Connecticut, those subpoenas, that summons for a criminal investigation, that would be where we need those witnesses, would be squashed, and I have an issue with that. The other, Mr. Speaker, I believe very strongly as a representative, as an individual, in a culture of life. Promoting a culture of life. I've seen many fetal pictures of fetal biology, seeing a baby very developed in the very early stages, in a number of weeks, days before. You have a heartbeat, just a number of weeks before you see legs and hands and fingers and a nose and ears are developed. I cannot in good conscience support any legislation that would expand the number of people that would perform these type of procedures. So for those reasons, I will be voting no on this legislation this evening. I thank you for the opportunity to ask the questions and the Chamber's indulgence, but I will be voting no on this legislation. Thank you, Mr. Speaker.
Representative, thank you for your questions, and thank you for acknowledging that you skipped the ranking member. We were able to work that out, so I appreciate that. We don't want Representative Pettit getting mad at you there. So.